best way to answer that question is, first of all, to address HOAs. If in the majority of HOAs in the state of Florida, you are dealing with single-family detached homes, so you're not attached to another unit. If that is the case, then the homeowners association typically does not have the right to access the home. Now, the exceptions that would typically be there for an HOA with a single family home that's not attached to any other home would be if you had a scenario where the house or the home is in such disrepair that it's creating some type of health problem. But typically the answer to that is to call governing body where you're dealing with governmental authority. So the city or the state or the county, and to call in their code enforcement or their health department and let them handle it instead of the association using self-help. But there have been some cases where HOAs have petitioned the courts and been granted orders to be able to access. But the cases that I've seen and that I've dealt with, those have been restricted to vacant properties. So typically the answer to that would be no, they do not have the authority unless it's some type of health or serious code violation and that you've already been through the governing bodies and they refuse to take any action, and you would have to still go to court to get an order to do so. In my opinion, I would always advise an association before, if they called me and said, hey, we want to go in and clean this place up, and they haven't taken the steps that I've just recited, I think that that would be an illegal move on their part. So I would suggest that they not do that. Now, when you're talking about HOAs that are connected, where the living units are connected to other units, and in condominium associations where that's typically the case where the units are connected, then you have issues where, and we talked about it with the mold or the leaky pipes, issues where one unit may very well affect another unit. And does the association have a right then to come in? Well, if it's occupied, then my answer would be no, because you would have to really address that with the owner that's there. And if the owner is refusing to help, then there are steps that you can take and you can go to court. If the owner just completely ignores any such request and is still causing damage, then I think you go to court and you get a court order. And once that's the case, then most of the time the unit owner would comply with allowing the association to have access, or to require the unit owner to fix the problem so the association doesn't need access. But it's not a case of, where you see in your typical rental agreements where the landlord, upon certain notice, has access to gain entry, or when you have a mortgage and the mortgagee is entitled to access under certain circumstances to protect their investment. With the association, it's much more restrictive. So typically the answer is no. And I think that the safest thing is to, if it's a connected unit, is to try and find the owner with the connected unit. Sometimes that's easy, sometimes that's hard, and resolve the issue there so the association doesn't have to actually enter into the premises. If that's not the case, and it's creating an immediate health problem, you could call the governmental authorities that I referred to, and you can also go to court and get an emergency order to enter so that that does not damage or destroy other units or common areas or limited common areas of a condominium association.